Welcome. So this is a short PowerPoint presentation reminding you for revision purposes of the topics we covered in the corporate governance course, and just enabling you to put your reading together. So the slide here and the following slide set out the characteristics of the corporation. The idea of this first session was to introduce the subject and analyze what we are going to study. And you can see here 6 criteria or 6 characteristics of a company. It's a legal entity. There's limited liability. We said limited liability for both shareholders and directors. The company owns property in its own right. It has standing in court, meaning that it can sue, and also it can be sued as a person in its own right. There is something called perpetual succession, meaning that the company continues to exist even if its shareholders die or otherwise stop being members. And that also means that the company continues to exist even if the directors disappear. And then another characteristic is shares are transferable, so shareholders can liquidate their investment in the company by selling their shares to someone else, and that does not affect the existence of the company. Then there are here now 5 more criteria or 5 more characteristics of the company. It has management under a board structure, so that's somewhat different from a classic partnership where the owners also manage. It borrows money in its own right, and it's the subject of taxation. And then there are, in these different legal systems, formalities need to be fulfilled, and there's an expense involved in setting up a company or a corporation. And of course, in modern times, formalities have been minimal and the expense has been low. And then also a characteristic of the company, there's publicity, meaning that there's Companies House in the UK. There are other official locations where the general public can inform itself about the affairs of the company. So what we have here in these 2 slides is an overview of what it is that we're going to study, and that's the company. Now, in the 4th slide here, we see a list of participants, and those are shareholders, directors, managers, auditors, employees, consumers, lenders, trade creditors, the community, and the environment. That's not an exhaustive list. It just shows you the width and breadth of the individual groups that come into contact with a corporation or a company. Now here is some law, or rather some sources of company law, and that's now for the UK. So there's the primary legislation, which you're now very familiar with, in the Companies Act, in the Insolvency Act, in the Financial Services and Markets Act. And then there is secondary legislation, and there are 2 examples. One is in relation to accounts, and the anchor for it is section 468 of the Companies Act. And there's also secondary legislation, which has, as another example, an anchor in section 657 of the Companies Act, and that's in relation to share capital. And then delegated rulemaking, also important. The Financial Conduct Authority and the Financial Reporting Council contribute to the body of rules that are relevant to companies. So that's sort of sources of company law. More sources here, the common law, in the UK case law, and then of course the constitution of the company, which is now consists of the original Articles of Association in their amended form. It used to be that we distinguished in the UK between a memorandum and the articles. That's no longer the case. The memorandum no longer has significance as a constitutional document. And the terminology in the US is slightly different. There we talk about a charter and bylaws. And then there's another form of regulation that can apply to companies, and those are shareholder agreements. Now we're now moving closer towards the heart of our topic, and those is the Corporate Governance Code. Corporate governance codes exist in many jurisdictions. We will have a particular focus on the UK code. The code is written by the Financial Reporting Council. It applies on a comply-or-explain basis, and the current code is the UK Corporate Governance Code 2018. Now, looking at the role of the Constitution, the Constitution is sometimes said to be a contract, and it is a contract in that it's adopted by the members of the company when it's first set up through contracting. And Section 33 ensures that the company itself and any subsequent members are bound by the Constitution. And then I think it's sort of from a legal perspective, it's not quite right to say the Constitution is a contract, because much of contract law doesn't apply to the Constitution. So there is a sort of, we need to be careful about this characterization at law, but it is definitely the case that the members adopt the Constitution, and they do so by agreeing to adopt it. Now, here is a distinction that I sort of introduced in this introductory lecture, and that's the distinction between the legal analysis and then the sort of academic theoretical analysis. Corporate governance as a field of analysis, it dates back, well, a very long time, as long as we had company law, but as a sort of distinctive field in its own right, it dates back to the late 80s, early 90s. And here's a definition. So it's the structure of rights and responsibilities of different stakeholders and its consequences for the process by which companies are operated. So that is sort of a classic definition of what corporate governance is. And the field of analysis is driven by corporate scandals. Now, here are the topics that we're going to look at. Theoretical foundation, shareholders, power of directors, corporate social responsibility, remuneration, skill and care, also no conflict rules, and auditors. So here we come to this analytical framework that I mentioned just now. And what you see is a shift that has occurred towards the 1980s or in the 1980s, and that is probably more in the US and then moved over to Europe. And it started out by an observation that company law or corporate law, if analyzed on its own terms, is boring. And the sort of the metaphor that was used to express that is doctrinal lawyers are sort of working on boring, empty towers of legal construct with nothing but wind. So that was sort of the critique of just looking at the law on its own terms. And then what was brought in is an idea from economics, and that is agency theory. So we started to look at the various participants in the company as agents and principals. So the analysis became one where we said we observed that what happens in company law is that some people act for the benefit of other people, or the acts of some people affect the well-being of other people. And in that analysis, the people who act are called agents, and the people who benefit or feel the effect of those actions are principals. So we can say in agency theory, directors are agents of shareholders. And that is because what the directors do affects the well-being of shareholders. They get more return or they get less return. We can also say that directors are agents of creditors, because likewise, what the creditors experience as an outcome depends to a large extent on what the directors do. Now, that analysis of the theory has, or that theoretical analysis has as a disadvantage that it's not quite accurate, because it sort of views the directors as acting in the interests of individuals, whereas in fact they're acting for the company. And then I'm also going to talk about my own project, which is a project on looking at companies as organizations, and that goes beyond agency theory.